Good morning, everyone. Thank you so much for joining us for today's webinar, Navigating Work Compensation and Other Insurance Issues During COVID-19. My name is Teresa Keene, and as of April 1st, I am now the Acting President and CEO of AgSafe. So glad that you can all join us today. I am very excited about our presentation today and partnering with Carlos Luna of Risco Insurance. Carlos will be presenting today's webinar, and Carlos is the Vice President of Marketing for URAC accredited Risco Total Managed Care and is a trusted advisor to stakeholders in healthcare, claims, managed care, insurance, and government agencies in workers' compensation. He is a recognized thought leader on national government agencies, workers' comp issues. Carlos's blogs have been published by industry-leading publications such as Work Comp Central, Work Comp Wire, Insurance Business Magazine, Louisiana Comp Blog, and more. And we are thrilled to be partnering with him today. So with this, I'm gonna run through a couple of slides just to get us started. We will be recording today's webinar. So if you want to go back and review what we've discussed today, it will be available on our website. We will send out an email letting you all know when it is up. And then also we will be doing some Q&A after the presentation today. Carlos has also agreed to help us put together a Q&A doc. So if we're not able to get to all the questions, which we will get to towards the end of the presentation, they will all be shared in the Q&A doc that we'll send after the webinar. So if you, let's run through the couple of the slides about if you can't hear, make sure that you're looking at the volume and audio settings down at the bottom of your screen. Next. And then if you can't hear us, you can also use the phone option. So with your registration, you were also given a phone number to call. So you can also call that number and listen in on the phone line. Just make sure that you have your phone on mute. And then today, to ask a question of the presenter, we're going to be using the chat function. So go ahead and put your questions in the chat function. I'll be monitoring them throughout the webinar, and then I'll be asking Carlos questions towards the end of the presentation. And with that, I would like to hand it over to Carlos. So Carlos, thank you so much for joining us today.
Teresa, thanks so much for having me. And by the way, congratulations on your recent appointment to Acting President and CEO of AgSafe. I know you're going to do a phenomenal job. And to the listening audience, thanks so much for spending a little bit of your day with us today. As Teresa mentioned, my name is Carlos Luna. I work for Risco Total Managed Care. For those of you that don't know much about Risco, we're a multifaceted, customer-driven company that provides claims management services or third-party administration claims, administration of claims, managed care services, and we offer workers' compensation insurance products to thousands of customers throughout California. I also have the privilege to serve as a board officer as vice president for the Hispanic Insurance and Risk Management Association. And those of you that have heard me speak in the past, you know that I've worked in workers' compensation for more than a decade. My career actually started on the front lines in disability claims, coordinating return to work. Over the years, my experience has developed into incorporating evidence-based medical standards and tools into the claims and clinical workflows to achieve improved healthcare, return to work, and financial outcomes for its users. I am very passionate about establishing a balanced work comp system that benefits all of its stakeholders. And as with any other presentation that you're seeing online, please be advised that the information I share today is for educational purposes only, and it should not be considered legal advice. So let me begin by setting appropriate expectations about today's presentation. The COVID-19 pandemic is truly unprecedented in every way. In fact, the challenges being presented by the crisis has left some of the world's most brightest minds perplexed. The data is not fully baked. In fact, with so much information being disseminated about the pandemic on a daily basis, one can say it's not even in the oven yet. Academics are hungry for dependable data that will help us better respond to the crisis. And in fact, California's WCIRB Chief Actuary, Mr. Dave Belushi, said it best. It's a challenging time when you have unprecedented systemic shock that's hitting a system that actually was pretty stable, referring to workers' compensation. You don't really know what the data is yet, and you don't know what the impact is. Now, I want you all to know I've spent a considerable amount of time pulling this information together for today's presentation. And my hope really is that you walk away a little bit more informed than when you dialed into the call. So with that in mind, let's dive in. We're going to have a couple of stops during today's journey. A fair amount of our time will be spent exploring the impact of COVID-19 and the impact that it will continue to have on workers' compensation. Secondly, we'll take a look from a 30,000-foot vantage point at COVID-19's impact on other insurance lines. And then we're going to wrap up our conversation by considering the path moving forward. I am going to do my very best to allow time for Q&A at the end of the presentation. If for whatever reason we run short on time, I'll make sure and share my contact information with everybody, and I'll be delighted to correspond with each of you all offline about any questions that you might have. As Teresa mentioned, we're also going to be working on a Q&A document that will answer any and all questions that come in resulting from this presentation that will be posted on the AgSafe website. So first, let's consider COVID-19's impact on workers' compensation. There are three major areas of interest for me that I want to discuss. The pandemic's effect on claim frequency, and I'm going to dive into other aspects of the claims process as well that I think will be beneficial for all of you to be informed on. Secondly, we want to discuss the anticipated impact on provider capacity. And then thirdly, the unfortunate effect that COVID-19 will have on return to work. There is a consensus among workers' compensation leaders that COVID-19 will have a material impact on claim frequency. In fact, according to a recent review by California's WCRIB's actuarial committee, declines in claim frequency, settlements, and liens have continued over the first 3 months of 2020. The decline in activity was mostly attributed to individuals staying home during the COVID-19 outbreak, and WCRIB actually stressed during their meeting that the numbers will look a lot different for Q2 as they'll include the full effect of the state stay-at-home order. As you might recall, California's Governor Gavin Newsom issued the statewide order prohibiting public gatherings due to coronavirus on March 19th. So we'll begin to see the full impact in the numbers beginning in Q2 of 2020, which are forthcoming. Now, the claim decreases can be attributed to a couple of reasons. A decline in workers' compensation claim frequency really has been consistent for some time, for years now. However, early numbers of the COVID-19 effect places declines between 20% and 40%, according to some experts. This is a significantly sharper decline than before COVID-19, or as my good friend Joe Peduta puts it, BC. Secondly, according to an announcement by the US Department of Labor, a record 6.7 million people across the country filed for unemployment benefits last week. California received nearly 879,000 unemployment claims between March 22nd and 28th, which is up from 186,333 the week prior. With business and government shutting down, workers are being laid off or furloughed. COVID-19 will continue to intensify the reduced frequency trend in workers' compensation. Now, while a sharp decline in claim frequency is expected in most industries and most business sector, I think it's reasonable to expect some industries to experience an increase in the claims due to COVID-19. Think of healthcare, first responders, agriculture, transportation. The drivers for the higher frequency in these industries will include the longer hours worked, effects from exhaustion, and the potential for higher exposure to virus due to the nature of their work. Experts have also opined that a spike in claims may occur as things start to normalize. Another colleague of mine, Mark Walls, made an astute observation recently stating that the spike in claims could come due to an influx of workers returning to work after being laid off. These workers, of course, will be both deconditioned and may have forgotten procedures and loss prevention policies. And, you know, in fact, I agree with Mark very much. After being absent for the workplace, some of our workers could very well be facing additional risk of injury due to deconditioning. So the million-dollar question that just about every work comp pundit, wonk, and thought leader has attempted to answer is, if an employee contracts COVID-19 on the job, is it an eligible workers' compensation claim? Well, let me begin by saying the world has seen numerous epidemics whose impact on the public's health has been very well documented. And you might expect to find guidance on compensability from these past occurrences. However, according to the National Council on Compensation Insurance, or NCCI, quote, "You will be hard-pressed to find meaningful information on how or even if workers' compensation was affected by SARS, H1N1, Ebola, and Zika outbreaks." So we can confidently deduce the answer to this question to be a resounding, irrefutable maybe. Here's the crux of the matter on compensability. The worker has to show that the illness or disease arose out of or was caused by conditions particular to their work, and that they had greater risk of contracting the disease than the general public. At the end of the day, eligibility for workers' compensation claims related to COVID-19 will have to be determined on a case-by-case and state-by-state basis. Claims from numerous business sectors have begun to be filed with various TPAs throughout the country. So we really should learn more about standards and precedences that are set along these lines in the very near future. A thorough review of the facts and circumstances will need to take place before a determination can be reached. And while workers' compensation laws provide compensation for occupational diseases that arise out of and in the course of employment, many state laws actually exclude ordinary diseases of life, such as a common cold or a flu. The more widespread COVID-19 becomes, the more difficult it may be for an employee to show that it is work-related rather than an ordinary disease of life to the public. As I stated a moment ago, claims specialists really have their work cut out for them. They'll have to investigate the facts of each case and evaluate whether an employee's illness related to COVID-19 occurred during the course and scope of employment. As with any claimed occupational disease, the medical evidence will be important to the compensability determination, including a formal diagnosis from a treating provider. A white paper was issued by Aon recently and explains why greater exposure to the greater general public tends to limit the liability for workers' compensation insurers. And I quote, "While every jurisdiction has specific laws pertaining to workers' compensation and communicable disease claims, the general rule for most industries is that the matter would likely not be deemed compensable if the employee was considered at no greater risk than the general public," according to the Aon report. Now, it goes without saying that there are occupational groups that are arguably at a higher risk or have a higher probability for exposure, such as healthcare workers, first responders, etc. Workers who don't work in healthcare may have a more difficult time claiming workers' compensation, though. They'll need to show that their jobs put them at a greater risk of contracting the virus. And while compensability issues will play out case by case, workers' compensation insurers in at least 2 states have decided that they will guarantee workers' compensation benefits for healthcare workers and first responders. Those 2 states are Washington and Kentucky. Washington enacted their standard on March 5th. Kentucky followed suit on March 13th. Numerous other states have actually introduced legislation for workers' compensation presumptions of compensability due to COVID-19. They include Alaska, Louisiana, and Florida. The state of Minnesota passed on Tuesday, which is yesterday, and is pending signature from the governor, a bill that could essentially add a presumption of compensability for COVID-19. Employees that are covered by the presumption would include peace officers and firefighters, paramedics, and emergency medical technicians, nurses, healthcare workers, correctional officers, counselors employed by the state or political subdivision at corrections, detention or secure treatment facilities, healthcare providers, nurses, and assisted employees in healthcare, home care or long care setting employees with direct COVID-19 patient care or ancillary work in COVID-19 patient units. Now, here's something that's a little bit different. Minnesota's bill would include workers required to provide childcare to first responders and healthcare. Why are these bills in these various states important? Well, as states begin to act legislatively and regulatorily, it does set a precedence and it adds pressure to other states that have not acted. And so it's very possible that these moves will in fact influence other states to do the same. So what about the Golden State? What about California? On March 19th, the California Labor Federation sent a letter to Governor Newsom's office requesting the creation of an emergency workers' compensation presumption for essential employees. Consequently, the letter was sent the same day that the governor ordered all non-essential workers to stay home to avoid person-to-person spreading of the disease. Now, it's important to understand, following the Labor Federation's letter to the governor, the California Applicant Attorneys Association announced on its website that it was drafting language for a possible executive order to be issued by the governor. Cause intent is to enact a presumption that would cover all workers that continue to work during the crisis. The presumption would cover employees deemed essential by Governor Newsom's March 19th executive order and any employees deemed essential thereafter. This would include employees that work and are important to the infrastructure of the state and the nation, which would include food and agriculture, as well as disaster service workers. You can rest assured that at Risico, we're keeping an ear to the ground. We're staying attuned to what's going on with this particular discussion, as it's going to have a material impact on just about every employer throughout the state. Now, workers' compensation costs are expected to increase during COVID-19 while the frequency is decreasing. The increase in costs will be driven by a number of things: extended disability duration, claims that will remain open longer, and continued high cost to deliver medical care. Now, employers and employees alike should take note and place a priority on responding to the issue of extended disability duration. In my experience, and according to the scientific evidence, prolonged disability duration has the potential to take a relatively straightforward claim and turn it into a complex, problematic claim that potentially will have a much higher cost. We'll spend a few more minutes on this issue here in just a moment, but I do want to emphasize this is going to be a critical time for TPAs and employers and insurers alike to respond to the challenge of extended disability duration during COVID-19. Employers should also be ready for existing and forthcoming claims to remain open longer. As you all know, across the country, state workers' compensation board offices have been closed to the public. Some hearings are being conducted virtually, but many are actually being postponed. And so for this reason, claims will remain longer and will add additional costs to employers and insurers throughout the country. Claim resources, including independent medical exams and field investigation services, are also limited, adding to the potential of being able to resolve claim issues. Of course, the byproduct of lower claim volumes is less capacity for workers' compensation treating providers. This is actually a pretty significant challenge. It's a big hurdle that we need to be aware of and work hard to try and navigate through. As the reduced claims volumes come in, many providers have been forced to temporarily close their offices. In fact, a column posted in Workers' Compensation this morning included statements from Concentra's CEO that they've closed about 20 health centers just in the last week. Concentra compared the drop in patient volume to the 2009 recession when volumes decreased by about 28%. Only COVID-19's impact in decreased patient volume is double that, according to the CEO. Similarly, nurse case managers are not seeing claimants, so medical services such as MRIs and other diagnostic tests may be inaccessible and are being canceled or postponed. Routine appointments and elective surgeries are also being canceled. And due to the lower frequency of injury, we're going to see less claims. It remains to be seen, however, whether we have enough capacity to manage through the claims that we are seeing that continue to come in during this time. We're also seeing a fair amount of transition among third-party administration companies. As claim volumes drop, we're seeing that some companies are starting to furlough their employers or their employees, or lay off their employees as well, which further adds pressure to those employees that stay on board to administer those claims appropriately. The unintended consequence, if you will, is that injured workers could potentially experience a delay in recovery due to limited options for medical care, which really is quite concerning. Now, telemedicine, however, is proving to be a valuable tool during the pandemic. It's offering a way for injured workers to keep appointments with medical providers while following social distancing guidelines. And while not every state has allowed the use of telemedicine and workers' compensation prior to the pandemic, some are easing their restrictions in light of the current circumstances. Telemedicine, however, may not be appropriate in all workers' compensation cases. So employers are encouraged to work closely with their claims advisors to determine where and how to best leverage telemedicine during COVID-19. So we all know that healthy and timely return to work is a critical component in the recovery of an injured worker and an important measure of success in workers' compensation. The COVID-19 outbreak is introducing hurdles that will negatively impact an injured employee's ability to return to work. This is a significant concern of mine, as it should be for many employers and TPAs and carriers throughout the country. The combination of restricted provider networks and an injured worker's reluctance to show up for their medical appointments could serve as a step in the wrong direction in return to work. Business closures and limitations on available work for injured workers who are progressing in their recovery and ready to return will be a major hurdle for employers to navigate during COVID-19. Cases in litigation will remain unresolved until state workers' compensation boards resume to normal operations. And as the science has proven, the longer injured employees stay away from their workplaces, the more difficult it becomes for them to eventually return to gainful employment. This is a major concern and should be a major area of focus for every stakeholder involved in the medical care and claims processes for workers' compensation. As for COVID-19's impact on other insurance lines, experts are still waiting to see how overall claim coverage goes. As with workers' compensation, several factors, including policy definitions, exclusions, and even the court of jurisdiction could influence whether coronavirus claims will be covered. For example, the intent of general liability was never to provide coverage for a pandemic. In fact, in some policies, there are clear exclusions for such coverage, such as an exclusion for communicable diseases. Now, the wording for these exclusions may vary, with some focusing on bacterial diseases and others focusing on viral infections. But depending on the wording in your particular policy, the exclusion may bar coverage for coronavirus claims. The most likely scenario for potential liability claim may be alleged negligence from failing to protect a customer or invitee from being exposed to the virus. However, it's also important to note that general liability claims could include those from an employee's family due to their workers' compensation claim. These claims could arise from exposure to the employer's alleged failure to use reasonable care to protect workers and their families. Insurers will argue, however, given the many warnings made to the public about the need to take action to prevent exposure to COVID-19, that there is no occurrence or accident. As with workers' compensation, the specific facts involved in each particular claim will play a large role in determining whether a particular coronavirus infection was caused by an actual occurrence. Now, under traditional property policies, insured physical loss or damage is necessary to trigger a response under that policy. If COVID-19 manifests at an insured's premises with people becoming ill, insurers could potentially contend that such effects are not physical loss or damage. Similarly, insurers can be expected to argue that possible contamination or fear on part of the public is also not physical loss or damage. Many property policies actually include coverage for business interruption loss, other time element coverages, and extensions such as interruption by civil authority and contingent business interruptions. Insurers will likely view those coverages as being triggered only by insured physical loss or damage followed a covered cause of loss, and thus meaning that no coverage will be available while the virus is present or suspected to be present. It's important to note that at both the federal and state level, regulators and legislators are considering measures and standards and policies that could potentially affect insurers' obligations relating to coverage of COVID-19. So the conversation continues to go forward. My comments today are not conclusive. We have to wait and see how this environment plays out at the national level to see what our particular state will do in response. As for auto, unless there's a specific loss, viruses are generally not covered under these policies. Generally speaking, pandemics in general, viruses are not covered under these policies, and they're not covered perils. So let's talk a little bit about health insurance. We've heard a lot about health insurance in the media. It really is in a different class. As you may or may not know, as of March 17th, NCCI stated that at least 10 states have issued mandates for coverage of coronavirus by health insurers. The directives are different from state to state, but generally include coverage for testing, visits to emergency rooms, or urgent care facilities without deductibles or copays. On the other side of the coin, it's important to recognize and to acknowledge that numerous insurance companies have launched initiatives to attempt to alleviate the impact of the coronavirus crisis on their communities. These insurers have created multi-million-dollar funds to support community partners. They've donated millions to relief efforts, such as Feeding America, the American Red Cross. They've also gone forward to create paying programs for creative services, such as paying additional living expenses for homeowners who are forced from their homes following a covered loss, or extended rental car days if a policyholder's vehicle is in a shop and cannot be repaired or returned due to closures. Insurers really are coming to the table with support. So you might be asking yourself, what is our path forward? It's a lot of doom and gloom, a lot of bad information. Well, there is a path for us to take. Employers really have to adopt a framework of collaboration. In fact, that goes for just about every stakeholder: insurers, third-party administration, third-party administrators, employees as well. And we have to work with one another to develop clear and detailed plans to manage a potential influx of claims. Though resources might be limited, employers, TPAs, and insurers should work together to ensure that these claims are thoroughly investigated, which is especially important given the prospect of more frequent fraudulent claims in the coming months and questions about the compensability of cases alleging exposure to COVID-19 in the workplace. Employers should also make the use of analytics in managing claims. Artificial intelligence and other tools have been very effective in allowing risk professionals and others to identify potential difficult or complex claims and prioritize them for early intervention. This could include assigning more experienced claims professionals and other resources to aid in their resolution, and being able to resolve these cases sooner than later, being able to identify the problematic long tail curve cases. You'll be able to dedicate better resources as the influx of claims continues throughout the COVID-19 era. Employers can also work with their advisors to close out legacy claims and reduce their backlog. This is going to be increasingly important. It's going to free up valuable resources to focus on the new claims that come in that could potentially use additional administrative and investigative resources. All in all, folks, I want to echo the fact that our industries have not lost sight of the human impact of COVID-19. Above all, during the pandemic, outreach to injured workers is more important than ever. The workers' compensation process can be difficult for injured workers to navigate under even the best of circumstances in the simplest of scenarios. Now facing questions about the economy, their job prospects after potentially lengthy recoveries, injured workers, whether facing possible COVID-19 infections or other injuries, may be especially anxious, especially fearful, and need an ally, a colleague that can help navigate them through this complex benefit delivery system. If they have not done so already, employers should consider adopting a claims advocacy approach to workers' compensation that focuses on communication, education, and transparency, which ultimately is a win-win-win scenario. It can contribute to superior claims outcomes, lower costs, and better health outcomes for injured workers. So definitely look into that claims advocacy approach process. And I'm happy to have conversations with anyone available on the webinar today that might be interested in discussing that further offline. If nothing else, let's be mindful of the power of words. Words have the power to reassure or frighten. They can signal interest and empathy or not. Words can build trust and confidence or create distrust and insecurity. They can create positive or negative expectations. Words have the ability to empower or undermine. They can grow relationships or sow feelings of alienation. I want to thank you all for your time and interest in these important themes today. You know, I definitely want to allow for some time for Q&A today. If you wouldn't mind sending them through the chat, and AgSafe will be sure and list those for us to be able to answer. Additionally, as we announced earlier, AgSafe and Risico will be working to post a recording of the presentation on their website, as well as include a Q&A document aggregating all of your questions from today's presentation. Thanks so much.
Thank you, Carlos. We really appreciate all the information you provided today. It really gave us a broad overview of things that we all need to be thinking about as employers, and also things to be considering as we're navigating this really uncertain time. Are you still available? I've got a couple of questions in the queue. Are you available to answer a few while we have a few minutes left?
Absolutely, Teresa, yes.
Okay, great, great. So our first question comes from Kelly, and she asks, are employers required to include the Families First Coronavirus Response Act leave payments in workers' comp insurance payments? If so, what classification code and rate should be used?
Those are all phenomenal questions, Kelly. I have to tell you, I'm not a legal eagle. I'm going to defer back to your lawyer to be able to answer those questions adequately. I will tell you that the federal government is definitely very adamant about making sure that employees are aware of the federal programs that have been enacted for their protection and their support. And while I can't tell you and give you advice on how you should administer that, I definitely will acknowledge the fact that the federal government is in a position to make sure that employees receive all adequate benefits during this difficult time.
Great. Thank you. Okay, Elena is asking, if an employee contracts COVID-19 and they notify their employer, are we to produce the DWC-1 or only if they claim they got sick from work?
It has to be a compensable injury, right? And so in order for that to be compensable, then you really have to follow the steps that your TPA establishes. Some of those steps are going to require a diagnosis from the provider. And so unless those elements are satisfied, then I think you need to move back to your business continuity planning and determine whether or not this person should create a workers' compensation claim.
Great, thank you. And then Gabby is asking, how would you go about approving if you contracted COVID-19 at work?
Well, that's the million-dollar question, Kelly.
Right?
You know, I think that we're all a bit stumped on that. While I think the human element really motivates people to try and do the right thing and go above and beyond for individuals directly affected with the COVID-19 diagnosis, I think from a carrier perspective and from a legislative and regulatory perspective, there are thresholds that need to be crossed. Some of those thresholds are going to include an actual diagnosis from a provider. They're going to include the employee showing that they were at a greater risk than the general public while on the job. Those policies and those thresholds are actually pretty difficult to cross. A lot more will be seen in the coming weeks as more and more claims are being administered by TPAs throughout the country. And I expect that a precedence will be set, but for now, I think that TPAs and self-administered employers are following traditional protocols to determine whether or not claims are actually compensable under their jurisdiction's workers' compensation laws.
Okay, great. Thank you. Got another question from Adam. He is wondering if you could please go back to the property insurance aspect. Did you say an employer may try to argue that the virus manifested itself on a job site or property of sort, therefore they may attempt to utilize their property insurance for business losses?
You know, I don't want to pontificate on potential scenarios, Adam. I will say that in some instances, I imagine the carriers are preparing for just about any and all claims to be filed, and property happens to be part of that element. under the circumstances, property damages, and this is coming, by the way, from a non-insurance wonk. My area of expertise is workers' compensation, but my limited knowledge of property policies is that there has to be physical damages. And I think carriers are preparing to answer these questions as they come up. And essentially the information that I gave you is the latest and greatest that's available out in the industry.
Thank you. And then Jacqueline has asked.
Sorry, Teresa, can I also add,
Sure.
you know, these standards could potentially be altered based on legislative activity in each jurisdiction. As I mentioned during the course of the presentation, there is added pressure being placed on insurance carriers to cover coronavirus damages and implications both to businesses and to injured workers. And so these policies could potentially change depending on the course and the precedents that is set nationally, legislatively.
Great. All right. Well, Carlos, let's see. Let's see. I've got a couple more popping in right now. Melanie is asking, there was mention of some states initiating regulation to cover family members of essential workers that may have contracted COVID-19 arising from employment. Can you elaborate on this topic, please?
So the state of Minnesota, I believe, is what you're talking about. They have a bill that they just passed through their House and their Senate. It's sitting on the governor's desk. And that particular bill could potentially cover family members of injured workers that are affected by COVID-19. Again, this is going to vary from state to state. And so please be cautious as you interpret these standards for your particular jurisdiction. You have to stay up to date with what your particular state is doing. As I mentioned earlier, in California, Governor Newsom is under some pressure to enact an emergency presumption under COVID-19. Whether or not the governor will act on this remains to be seen, but there are a couple of groups that have placed interest in seeing the governor move forward in that direction. But I don't believe anything has come about as a result of those conversations.
Okay. Great. And then Jacqueline is asking if there are any postings that need to go into the IIPP binders for the agricultural industry for COVID-19. Jacqueline, I can chime in on this one, Carlos. Well, you need to make sure that in your IIPP that you actually have, essentially you can do an addendum to your IIPP that addresses COVID-19, and AgSafe is working on right now a template to help you complete that part of the requirement. So we will be providing some assistance with that. And just check, I'm reading another one, seeing if we covered it. Okay, if the precedence is changed, proving on how COVID-19 is contracted or what qualifies as a claim, later after the earlier claims were filed, would we need to go back and review those claims?
Again, I'm going to have to punt on that one, Teresa. I think it's important for employers and for TPAs to engage their legal eagles on these issues. It's an unprecedented time. And so I think we need to stay up to date with what's going on legislatively and regulatorily, and make sure that we follow the standards that are set before us. Make sure that we're doing the right thing by way of set expectations and set standards. But I'm unfortunately going to have to punt on this one to your legal resources.
Absolutely. And then one last question. It's from Michelle. Carlos, she's saying, Carlos, that was a great presentation. I'm sure that is really difficult, again, to prove where someone may have contracted COVID-19. How can we ensure that employees understand that the fact, and educating them and getting them to understand that employers are doing all they really can do to protect them by implementing the social distancing recommendations?
Well, I think that's an ongoing effort, and I think this is a great question. You know, I really intentionally wanted to make sure that we included the human element at the closing of the presentation, because at the end of the day, it really is about keeping one another safe and helping one another understand that the limitations and the precautions that are placed at the work site and even in society these days are intended to protect us. I think that the best way to do that is to create ongoing communications, being transparent, showing from a leadership perspective that you believe in these protocols, and essentially making sure that you take an active role in your employees' safety. It's not going to go unnoticed. And I think, you know, there's an old saying, Teresa, that I was told many years ago: people don't care how much you know unless they know how much you care. And so I think during these times, particularly as it pertains to workers' compensation, a system that can be so bureaucratic, so difficult to navigate, again, under the simplest of terms, if your injured workers have questions, this is the time for your organizations to shine and to show that you care. Go the extra mile. Make the call to your lawyers, make sure you've got adequate guidance, talk to your TPAs, call your carrier if you have any questions pertinent to specific policies that you might have, and really be that source of knowledge and support for your injured workers. It's a day-to-day role. It's a day-to-day job that you have to carry out, but I guarantee you that over time, your employees will come to appreciate and understand that what you're doing is really in their best interest.
Carlos, I think that's a great thought to close on for today. Thank you so much for your time and providing us this information. We're incredibly grateful for your insight and all the information that you provided today. So thank you again for joining us. As I mentioned, we'll be sending out this presentation. We've got a recording of it, and then we'll also include some Q&A. So, and then Carlos has also provided his contact details. So feel free to reach out to him if you have additional questions.